Professor, congratulations.
Thank you.
I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Welcome back to the Hill Debate, where we break down the toughest questions in American law and politics. Today, we spotlight a tense exchange between Senator John Kennedy and a judicial nominee who defends interpreting the Constitution through its original public meaning. Senator Kennedy presses hard, raising Brown versus Board of Education, racial integration, and how courts should handle ambiguity in the law. This debate cuts straight to the core of constitutional interpretation, originalism versus modern application.
Senator Kennedy.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator, at the time.
But first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the.
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean
what
with
about?
those. Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have.
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history of statements one by one because
Why not?
the individual
Why not?
intent... Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
The hearing room was tense, and the exchange between Senator John Kennedy and the judicial nominee captured a broader struggle in American constitutional interpretation. At its core, the debate was about how we read the Constitution and what weight to give to history, text, and evolving principles. Kennedy's questions, sharp and insistent, forced the nominee to confront the hardest cases for originalism, none more famous than Brown v. Board of Education. When Senator Kennedy began by asking what original public meaning means, the nominee responded with a textbook definition. It refers to interpreting the Constitution according to the meaning the text had to the public at the time it was ratified. That answer placed him firmly in the originalist tradition, a school of thought associated with jurists like Justice Antonin Scalia and Justice Clarence Thomas. For originalists, the Constitution is not a living, evolving document that changes with society's values. Instead, it is fixed, bound to the meaning its words had when adopted. But Kennedy's questioning strategy was deliberate. By tying originalism to Brown v. Board, he pressed on a weak point. Brown, decided in 1954, is universally hailed as a cornerstone of justice in American constitutional law. It overturned Plessy v. Ferguson and the doctrine of separate but equal, declaring racial segregation in public schools unconstitutional. Yet, if constitutional interpretation is fixed to public meaning in 1787 or 1868, then how does one justify Brown? Did most Americans at those times really believe that the Constitution required racial integration? Kennedy suspected not, and he pressed the nominee repeatedly. Do you think the majority of Americans at the time of the Constitution's drafting supported integrated schools? The nominee resisted the framing. He did not want to concede that Brown was inconsistent with originalism, because that would put him at odds with one of the most celebrated Supreme Court decisions of all time. Instead, he shifted the focus. He argued that the 13th, 14th, and 15th Amendments, passed after the Civil War, transformed the Constitution. They embedded principles of racial equality that had not existed in 1787. The 14th Amendment in particular, with its Equal Protection Clause, demanded that all people be treated equally under the law. That principle, he argued, could be applied to the question of segregated schools, even if 19th century Americans were not thinking directly about classrooms. Kennedy did not let go. He asked again, "Do you really believe that most Americans in 1868 thought the Constitution required integrated schools?" The nominee admitted he did not know the sociological breakdown of opinion at that time, but emphasized that the principle of equality was clear. The Civil War had been fought, and hundreds of thousands had died to vindicate the idea that slavery and racial caste systems were incompatible with the Constitution. Even if practical integration was not widely supported, the text of the 14th Amendment provided the foundation for equality. Here, the deeper divide becomes clear. Kennedy's line of questioning rested on the assumption that public opinion at the time of ratification defines public meaning. If most Americans in 1868 did not support integrated schools, then original public meaning would not support Brown. The nominee, however, drew a distinction between majority social views and the principle enshrined in the text. The Equal Protection Clause does not depend on whether a majority of Americans practiced or supported equality. It declares equality as a constitutional command. Thus, under original public meaning properly understood, segregation violates that command. This is the classic tension in originalist thought. Does original meaning capture the specific expectations of the ratifiers, or does it capture the general principle they enacted in text? If it is the former, then originalism risks freezing us in time, bound to the prejudices and blind spots of earlier generations. If it is the latter, then originalism can adapt, because the principle of equality, once embedded in text, applies even in contexts that the ratifiers never envisioned. The nominee clearly adopted the latter view, seeking to reconcile originalism with the moral authority of Brown v. Board. Kennedy's strategy was to force a binary. Either original public meaning controls, in which case Brown is difficult to justify, or Brown was right, in which case originalism must be more flexible than its defenders admit. The nominee avoided the trap by pointing to the Reconstruction Amendments as transformative. They reshaped the Constitution and supplied the textual foundation for later rulings on equality. The exchange then shifted from constitutional interpretation to statutory interpretation, a related but distinct field. Kennedy asked, "When you interpret a statute and it's ambiguous, what do you do?" The nominee began with the standard approach. Start with the plain text, examine the surrounding provisions, and try to discern the meaning from the enacted language itself. Kennedy pressed, "But how ambiguous does it have to be? 51% ambiguous? Just a little ambiguous?" His point was to challenge the idea that ambiguity itself is a clear threshold. If all language is somewhat indeterminate, then how do judges decide when to stop reading text and start looking at other sources? The nominee cited the Supreme Court's Chevron doctrine, which emphasizes that courts cannot simply stop at declaring a statute ambiguous. They must reach a resolution, often deferring to agency interpretations if the law is genuinely unclear. But Kennedy was unsatisfied. He wanted a crisp answer about where to draw the line. The nominee resisted, explaining that ambiguity is not a mathematical percentage, but a matter of careful analysis of context. Kennedy then shifted tactics. Why not just look at legislative history, he suggested. That committee reports, floor speeches, and congressional debates could clarify what Congress meant. The nominee pushed back firmly. Legislative history, he explained, can be a useful aid, but cannot carry binding legal force. Individual legislators may say many things, but only the text of the enacted statute, passed by both houses and signed by the president, has the force of law. If judges gave decisive weight to legislative history, they would risk cherry-picking statements that aligned with their preferred outcome. Instead, legislative history should be used sparingly, as one piece of evidence, never as a substitute for the law itself. Here again, the exchange touched on a long-running jurisprudential divide. Textualists, following Scalia's lead, argue that the text alone is the law. Legislative intent is messy, unreliable, and impossible to pin down from selective quotations. Others argue that ignoring legislative history means ignoring how Congress actually works. After all, laws are often compromises, and legislative history can shed light on what ambiguous words were supposed to mean. Kennedy, by pressing this point, sought to expose whether the nominee's textualism was too rigid or whether he would allow legislative history a meaningful role. Beyond the substance, the hearing revealed contrasting rhetorical styles. Kennedy favored brevity, bluntness, and cornering questions. He interrupted long answers, demanding yes or no clarity. The nominee favored nuance, caution, and careful explanation. He resisted binary choices, insisting on context. This clash of styles mirrors the clash of philosophies. Kennedy representing the frustration of politicians who want straightforward answers, the nominee embodying the caution of judges who know that simplistic answers can distort complex principles. Why does this matter? Because the debate is not just academic, it shapes real cases and real lives. If courts embrace Kennedy's implied approach, tying constitutional meaning tightly to majority views at the time of ratification, then landmark rulings like Brown, Loving v. Virginia, interracial marriage, and Obergefell-Hodges, same-sex marriage, become harder to justify. After all, majority opinion at those times did not support such rights. But if courts embrace the nominee's approach, focusing on constitutional text and the principles it embodies, then those principles can be applied across generations, to new circumstances, ensuring that equality and liberty evolve without abandoning original meaning.
The exchange also highlights the political stakes of judicial confirmations. Senators are not only evaluating qualifications, they are probing philosophy. A single justice on the Supreme Court can determine the fate of national policies on voting rights, abortion, healthcare, civil rights, and beyond. Kennedy's aggressive questioning was designed to pin down the nominee's philosophy and expose potential contradictions. The nominee's careful answers were designed to avoid traps while preserving fidelity to his judicial method. Ultimately, the exchange dramatized the central question of American constitutionalism. Is the Constitution a fixed document tied to the views of past generations, or is it a text of enduring principles applied to new realities? Kennedy and the nominee sparred over that question in the language of original public meaning, Brown v. Board, ambiguity, and legislative history. But behind the words lay a deeper struggle, one that will continue in hearings, courtrooms, and classrooms for generations to come. This exchange shows the tension between senators who demand clear-cut answers and judicial nominees who insist on careful, principled nuance. Whether you agree with Senator Kennedy's challenges or the professor's defense, this debate raises fundamental questions about how our Constitution should be read today. Stay tuned for more debates from Capitol Hill, and don't forget to like, subscribe, and share your thoughts below.